How is it out there, by the way? And it's like 80 degrees out here today.
It's about 70.
Nice.
Just sunny and a little breeze and not a cloud in the sky.
Nice. Nice. Hey, Roundup family. Good evening. Good evening. Greetings to you. Greetings. Come on, log on here and give you a few minutes to get logged in. We got 11 people waiting here. Anything interesting in the litigation world that we need to know about, Bill, while we're waiting for my Roundup homies to log on?
So I went to court the other day representing a nephew of an old friend of mine who was being evicted for non-payment. He had a legitimate defense. The furnace hadn't worked in 8 months. But there's a CDC ban on non-payment evictions.
Yeah.
And so I read the ruling, and I sent a copy to the plaintiff's attorney along with an affidavit from the CDC's website. He signed. It says, I qualify for this ban. And I said, you got to withdraw the case because, I'm not threatening you, but your client can get hit with a $100,000 fine and up to a year in prison for violating this. So I showed up in court with the client on Wednesday, and the doors are locked to the courthouse, to the courtroom. I'll go over to the clerk, and I said to file the answer. And I said, what's the story? And she says, well, I don't know, really. I guess you just give your paper, then if the judge wants to hear it, then they'll email you and schedule a Zoom meeting.
You're joking, right?
Yeah.
Joking, dude.
Okay. Usually I'm used to showing up, then there's 50 cases and there's a clerk and then you check in and then they say go in the hallway and work it out. But I'm just curious to see how this works out, if the judge dismisses the case, and if he does, he awards attorney's fees, because it's like bad faith.
This is crazy, Bill. Meanwhile, the poor landlord, what's his story? Mortgage?
Well, it's not a poor landlord. The guy owns it free and clear, but he had a friend locally, because the guy lives in New York, managing the property with a lease under his own name, and he's not a broker. Like, you can't put a lease under your own name if you're not a broker.
Oh, my
That's
Lord.
brokering without a license. You can't property manage in Colorado without a broker's license. So
Really?
he counterclaimed, and so we went all the red back. So we'll see what the judge says about that one.
Bill, you got some mess. That sounds like some mess.
Hey, when I'm representing a client, I got to go all out, even though I'm a landlord too. He was a nephew of an old friend of mine, so I had to play the part.
That's crazy. Roundup, welcome to, I'm telling you, man, the litigious world of real estate.
Yeah.
If you're in this business for any length of time, you will be in the legal system.
Yeah, I'll tell you a quick story, though, about another client that's relevant to our discussion. He took a property subject to about 18 years ago, and he did it by putting it in a land trust, it was Joe Smith's trust.
Joe Smith was the seller?
Yeah. So he put it in the Joe Smith trust with my client as the trustee and Joe Smith as the beneficiary, and then simultaneously assigned the beneficial interest to my client's LLC. Okay. It's not my favorite way to do it because it creates some confusion, especially when you call it Joe Smith Trust. But anyway, It was clean. The docs were clean. So for 18 years, my client collected the rent, paid the expenses, paid the mortgage, just like any old subject to. And he's getting ready to sell it for like a monstrous profit for all these years. And we get a letter from Joe Seller's ex-wife who said he didn't disclose the ownership of that property during the divorce in 2006, which was 4 years after the transaction. And we said, well, it's irrelevant. He sold it, right? He sold the property. And she files a list pendants on the property.
I would too.
And she says, you were working some fraudulent scheme with him, giving him money under the backside. I said, first of all, 18 years is the statute of limitations for adverse possession. So no matter what claim you have, you lose it after 18 years of the property. Good. Second of all, here's the document. Here's the land trust. I showed it to her. Here's the assignment of beneficial interest where he gave everything up to my client, gave up all rights to the property. And she still filed lis pendens claiming that my client and the ex-husband were defrauding her somehow, that he still had an interest in the property, which he didn't.
Oh, I see.
He didn't all these years. But, it's just to show you how, some lawyers can twist things and tie you up, even though she doesn't have a leg to stand on. Because in Colorado and in most states, when you file a lis pendens, you have a certain amount of time to file a lawsuit. So 35 days in Colorado, and that ends in a week. So we're going to see what happens here. I seriously doubt she is going to, and she's claiming it because for unpaid alimony. So she's saying this property still belongs to Joe Seller because it's the Joe Seller trust.
Okay, so she's not even. If I was her, I'm like, it would sound like the husband did some shady back office stuff trying to keep the title in his name, but he really got it out of his name and
right. It would have been would have been a lot cleaner and in her perspective more understandable if Joe Seller transferred it to my client's property address trust.
Yeah,
it's still legally the same thing, but you can see how doing it one way can create confusion in the mind of a moron, who's alleging all kinds of things, and that's the problem. The title company won't close it.
I'm telling you, man. You know what? The worst I've done close to that, I just used the last name, Bill. Well, now, how do you feel about the last name trust? Not the whole name.
I don't even see the only reason that it's preferable to do it that way, like Smith Family Trust, is when you get the insurance in the Smith Family Trust. That makes it easier with the insurance. That's definitely true.
Yeah,
but you could see the confusion that it can create. With the seller, in this case, the seller's ex-wife.
It's nasty.
And even her attorney, who's a dopus, who didn't get it either.
Well, that goes to show you, even experts don't understand this trust stuff, Bill.
No. Land trusts are common, or were born out of Illinois. Chicago Title invented the land trust. It's statutory in Illinois. It's statutory in Florida, Indiana,
Virginia.
I think Maryland or Virginia, one of the two.
I know Virginia.
Hawaii, and about maybe 3 or 4 other states. The rest of the states is just not commonly used. So when you ask an attorney, land trust legal in my state, they're probably going to say no. And that's not true because they're common law creations by contract law.
Nice.
And in a lot of states, there's been court cases that validate it, even though there's no statute.
Now, when you say the statutory, Bill, what do you mean by that?
You mean there's a law on the books that says a land trust is defined as X. Here are the rules.
Gotcha.
Just because there's no statute doesn't mean it's not legal in that state.
Well, thanks for dropping that info on us. Way out of what we were going to talk about today, but thank you, Bill.
But it's along the lines of subject to and wraps. So
yeah, that's true.
Segue.
That's true. Segue. Yeah, you're right. Roundup. Bill's going to give us some goodies today. Columbus Day. I thought it was President's Day. I thought Friday. It's Columbus Day, Indigenous People Day.
Right.
Bill,
it says both in my calendar.
Yeah, man. We got a sponsor now, by the way, y'all. PropStream is sponsoring the show, and go up there.
I like PropStream.
Yeah, Kris Property Data. They gave me a hookup, a discount. So go ahead and head over there. Not now, but you can pull your data, all the mortgage information, owner, all that. Do you use PropStream too, Bill?
Oh yeah, I've been using that software for probably 15 years before it was online software. It used to be a desktop app, and then it became like a desktop with access to the internet, and now it's become a totally web-based, really quick software. Really good.
You've been around, dog. You've been around. Sheesh.
Yeah, so, for a long time, Rich Dad, under a different name of the software, private label it to his group as part of their $40,000 coaching.
Roundup. Thank you for joining us. I am Kris Haskins. My mission and ministry is to raise your financial literacy through real estate investing and entrepreneurship. Today, we get to hang out with attorney Bill Brunchick. So what's going to happen if you get your questions in a box? We put out a video over the weekend and got 1 million comments about wraparound mortgages and when to use them and subject to. So we're going to just kind of do an overview of subject to. Bill can give us his short perspective, but really about, I know Ron LeGrand is saying the legislators are frowning on this subject to stuff, and I don't know if it's going to get teeth. As it starts to, when one state likes it, kind of moves around.
Mm-hmm.
I want to know your opinion on that too. So, Bill Brunchick, how you doing, my friend?
I'm doing awesome. Thank you.
It's good to see you again. Round up. So, get your questions in the chat box. Bill, subject 2. Let's start off with sub 2, and then we'll go over the wrap notes so people can kind of understand the dilemma we're all in.
So subject 2 means buying a property subject to the existing mortgage or deed of trust, the existing lien. You don't pay it off at closing like you normally do. You leave it in place and you continue making payments on the underlying note. So what you're taking title subject to. If you look at a deed, it says, I grant and convey the following interest subject to, and then there's, subject to unpaid taxes that are accrued but not due yet, subject to zoning restrictions, subject to an HOA rules, subject to an existing first mortgage to Wells Fargo, loan number, blah, 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 blah.
Mm-hmm.
So that's when you take subject to, it says so right in the deed.
Nice.
Subject to the existing mortgage. In fact, I hear attorneys and title companies say, and brokers say it's illegal. The HUD-1 form has a line right there that says subject to existing mortgage, as opposed to assuming the mortgage. Assuming the mortgage is where you call up the lender and say, please put me on the hook, which I don't know why you'd want to do that. But by doing that, it releases the seller from any liability for the loan. So you're assuming his loan and qualifying for it, which you can't, because in 98% of the cases, the loan you're taking subject to is a residential owner-occupied loan. So you can't take that. You can't assume it unless you're going to live there.
Mm-hmm.
So if you're not going to assume it, you take it subject to the lien, which means you don't sign the promissory note. It's not on your credit report. It's not your liability. If you don't make the payments, it affects the seller's credit, not yours. And of course, if you don't make the payments long enough, the bank still has a lien, can foreclose the property. So ownership changes hands. The deed transfers, but the lien remains with the property. The lender is still secured. Yeah. A lot of people don't get that dichotomy of, well, how can you transfer the property? There's a mortgage on it. Don't you have to transfer the mortgage? And that's only an assumption. An assumption has nothing to do with the lien. It has to do with the underlying promissory note.
Mm-hmm. I remember
that's subject to. A wrap is when you're going to create let me start by saying there's 2 ways to do a wrap. The traditional way of doing a wrap would be a title changes hands from seller to buyer subject to the first, and then the buyer gives the seller a note that is what's called all-inclusive with a second all-inclusive mortgage or trust deed. What do I mean by all-inclusive? Let me use some round numbers, okay? Now I know some of you watching this is not realistic numbers, but I'm going to use round math so you can follow me. $100,000 house, right? The seller owes 95. Okay, so he transfers the properties to you subject to, and you make the payments. That's one way to do it. But the seller has no recourse if you don't make payments because he gave away the property. It's like in a divorce where husband and wife often do this, where they're both on the property, and then husband claims his interest to the wife on divorce, and the wife promises to refi within 3 years and then doesn't make the payments. The husband's still on the hook for the note, right? Still on his credit, and foreclosure will affect his credit. It's the same thing. So if a seller either A, wants some sort of recourse where they can do something, if you don't pay, that second lien allows them to foreclose and get the property back. Okay. Now, in that case, you'd have a $95,000 note to the seller that mirrors his underlying $95,000 note. That's called a mirror wraparound. Okay, mirror wraparound or mirror wrap. What's the difference between that and a subject to? The seller has a lien on the property. So if you don't pay, the seller can foreclose and get the property back. Okay.
Gotcha.
Otherwise, it's the same thing. It's the same basic process. You're making payments to him that mirror his existing payments on the note. I wouldn't make it directly to the seller. I'd make it directly to the lender. But in theory, you make it to the seller and the seller makes it to the lender, in theory. Now, if there's equity in the property, let's say it's worth 100 and he only owes 60, you have two choices. You could buy his 40,000 in equity for a chunk of cash, like let's say 10 grand, and take it subject to, or you can give him a little bit of cash and a promissory note for his equity. Now, instead of taking a second, let's say $100,000 house, $60,000 first, he agrees to take 10 grand, which leaves still 30 left. You give him a note for 30 secured by a second lien on the property, and you take subject to. Okay, that's one way. With a wrap, you would give him 10 grand down and a note for 90. That's all inclusive of the underlying 60. So there's 150,000 in liens, but not really, because the second lien, the all-inclusive mortgage or deed of trust, will say this is inclusive of the first. That's why they call it an all-inclusive note. In deed of trust states, they're called all-inclusive trust deeds, or AITD. In mortgage states, we do what's called a wraparound mortgage, but it's the same thing. It's an all-inclusive wraparound mortgage. Okay, so there's a wrap with equity. There's a wrap without equity. Those were two examples I gave. Now, that's when we buy. You want to get the deed, because if you don't get the deed, all kinds of bad things can happen to the seller that can affect your equity. We could turn around and resell that property on another wraparound. So let's say, go back to our first example. It's worth 100. They owe 95. 3.5% interest. You get the deed and give him an all-inclusive note of 95 that mirrors his underlying 95 at 3.5%. Then you sell it to another buyer on another wraparound for, let's say, 110. Get 5 grand down and then carry 105 at 6% interest. So the difference between 6 and 3.5 is a spread that translates to several $100s a month in principal and interest payments.
For that first.
On that first. So when you sell on a wrap, there's a different way to wrap it. And that way is to use what's called an installment land contract, also known as a contract for deed. Same thing. In Louisiana, they call it a bond for title. It's the same thing. In that scenario, you're not giving title to the buyer till they pay you off on the contract. So you buy in a wrap, you sell in a wrap. When you buy, you try to get the deed. And when you sell, you try not to give the deed. Sell on a land contract or installment land contract or a contract for deed, it's all the same thing. So the buyer makes you payments on the $105,000 note at 6%. You're going to make payments on the underlying note at 95 at 3.5%, and there's a spread. Why at the end pays the taxes and insurance and the maintenance and the repairs, and it's not a rental situation. Okay?
That's deep. You know, when you're the first.
I know there's a lot of little pieces to that, but I just want to get the general concept of buy low with a low interest rate, sell high with a higher interest rate.
But you don't even have to sell that high.
Interest rate, right?
The financing is high.
Pardon me?
I mean, you're not even selling that much higher, really. Technically, you're just the financing is higher.
3 points higher. You know, if the underlying loan is 3.5, I'll sell it 6 and 6.5. What I want the cash flow. If I charge him 9, he's going to run out to refinance in a year, and then my cash flow goes away. So you want it to be high enough that you make a profit, but not so high that they're going to go, this is ridiculous. I got to refi.
Well, I was more or less thinking about the price, Bill. I mean, I almost don't even care about the price when it comes with when you're able to make money on that entire first. I mean, it's just really unbelievable.
Right. You're making, so if you bought it for 95 and you sold it for 110, you're making 6% interest on 15, and you're making 2.5 points on the other 95. That's the power of the wrap.
Golly, what is
it's like this? I mean, if you go to a bank, right, you put money in a savings account and they give you 0.5% interest. And then they give you a car loan for 5 or a mortgage loan for 4. It's the same thing, right? You're just borrowing money and then relending it.
Be the bank.
Be the bank.
Be the bank. Let's talk about this recourse thing, Bill, as we get to wrap notes. Why do I care whether the seller, I just want my rounduppers to understand, including me, who cares whether the seller has recourse? Why is it a problem?
To be honest, 98% of the time, the seller really doesn't care. Never bothers to question or ask, hey, what if you don't pay? Because typically a subject to scenario is someone who has A, no equity, and or B, behind in payments, and or C, is just mentally giving up and saying, I'm walking. The bank can have it.
Mm-hmm.
So they could care less about whatever details about their credit being, screwed up or losing the house to foreclosure. They just don't care. Occasionally they do care. And if they do, you buy on a wraparound.
Gotcha.
I'll admit, probably 9 out of 10 times I just do a subject to. But if they bring up that issue of, well, what happens if you don't pay? And then I give them the wrap scenario. If you're a broker out there, real estate broker, this is the proper way to do it. Especially if you're a transaction broker, because it's more even in favor. When you buy subject to, it's totally in favor of the buyer. The seller has no rights, right? When you buy on a wraparound where you get the deed and then give back a lien, it's a little more even fair. So if you're a broker in a transaction, and by the way, if you're a newbie and you go around asking title companies, do you do subject to closing? 9 out of 10 will tell you either A, I never heard of such a thing, or B, no, we don't.
Listen up here, y'all.
Don't. Say, do you do wrap closings? 9 out of 10 will say, oh, I remember those back from 1983. Yeah, we'll do those. Because in think back 1983 or 79, 81, interest rates were, 15, 16%, commercial over 20. So people did wraps back then to preserve a low interest rate.
Gotcha.
So if you had a 6% loan and market rates are 15, you could wrap it at 10 and make a cash flow, right?
Wow.
But these days we don't do it for that reason because interest rates are low. We do it to make a cash flow spread, to make financing easier so we can sell the house quicker to a buyer who can't qualify through traditional means.
Mm-hmm.
And banks don't care about calling in loans that, because of the acceleration or due on sale clause, because interest rates are falling, they're not rising.
Mm-hmm.
Why would a bank call in a 4% loan when rates are 2.8?
Yeah, good point. Well, Bill, I want to understand and paint a picture for my round-uppers. And y'all get your questions in the box. We're going to get to your questions real quickly, and I'm going to give you some goodies too. Bill's giving us a Columbus Day special. Bill, why don't we buy like we sell? I know you said that earlier. And if you're buying on a wrap, you're selling on a land contract.
Right.
Why does it matter?
Generally speaking, getting a deed entitled into your name gives you more protection because if, let's say the seller goes and files bankruptcy, he already gave up the asset, right? Mm-hmm. So it doesn't get tied up in a bankruptcy. On a land contract, that's what's called an unfinished contract, or executory in legal terms contract, mm-hmm. which the trustee in bankruptcy can cancel. Mm. So if you bought on a land contract or contract for deed and the seller filed bankruptcy, the trustee in bankruptcy can cancel that contract. When you get the deed title to the property and the IRS decides to file a lien against the seller, there's no lien against the property because it's no longer in his name. So there's all kinds of things that could happen between the beginning of a land contract and then when you finish it and get the title.
So we're getting the title on a mirror wrap. We're getting the title, but we're not giving it away when
we're not giving it away. Now, the only exception to that would be those of you who are watching in Texas. In Texas, land contracts are effectively outlawed because they regulated them to death to the point where they're unusable. Same thing with lease options. So people buy on a wraparound mortgage, actually it's a trust deed state, so they buy on an all-inclusive wraparound trust deed, and they sell, giving the title to the buyer on an all-inclusive trust deed. But the good news is the foreclosure timeline in Texas is 21 minutes. I'm sorry, 21 days.
21 days. Okay.
21 days. that unbelievable?
I'm thinking about lease now. What can lease options get through it? I'm thinking about a sandwich. Everybody's doing these sandwiches now. Bill, can that get clouded up too with the bankruptcy trustee too?
Yes, it's an
Oh my
executory contract.
Lord,
It's an executory contract.
that's scary.
Yeah. I mean, it rarely happens, but occasionally it does. Believe it or not, most people don't realize this, but if you do a lease option with someone, a master lease option, and then sublet it and make payments on the loan for a year and go back to the seller and say, will you just deed me the property? 9 times out of 10, they'll say yes.
Wow. Turn it into it.
Right. So you start out soft, easy, lease option, very non-threatening. Later on that road, you establish rapport and trust, and they're like, oh, sure, why not?
That's a good nugget right there.
Yeah, how about an extra $500?
Well, Bill, I'm just thinking about that ex-wife you're dealing with now. If that was a lease option, that might get sticky, correct?
Yes.
Oh, man, Jesus.
Very sticky.
Because she's coming back.
The client wouldn't have had ownership. Yeah, there's a lot of things that can happen in between the beginning and the end of a lease option. Now, having done like so many of these things, I could say it's pretty darn rare.
Yeah.
But the seller could die. The seller could file bankruptcy. The seller could get an IRS lien against the property. He can get there's all kinds of little things that could happen, which is a risk. It's a risk. I think it's a risk worth taking. You vet the seller, you know his story, and see what the potential things are. Ask him, do you plan on filing bankruptcy? Because if you do, call me first. Deed me the property, then go file bankruptcy.
So are there any keywords or something that's going to set a red light off when our investors are negotiating with the seller to deploy the wrap note, Bill?
The reason I don't like buying on a wrap as opposed to just like buying subject to is explaining it. It's very difficult to explain.
Yeah, can imagine.
It's very difficult to explain. Usually I keep it simple, like, well, why don't you just transfer the house to me and I'll make your payments? And then later I explain, I don't even use the word wrap. I just say, we're going to give you a lien against the property, so if we don't pay, you can foreclose the property back.
I like it.
I refrain from using the word wraparound, all-inclusive trustee to the seller. That's just going to blow their mind. And, a confused mind says no.
That's cool. We got 90 people on here now. Sorry. 90 people on here interested in this rap stuff. I just think that it's being talked about more as grandma and grandpa are trying to come back and say, subject to, well, he bought my house and I don't know this stuff.
I've never bought a house from a grandma or grandpa that was an idiot or like I feel like I took advantage of.
Good.
Never. I mean, most of the idiots that I've dealt with were younger. But no, yeah, I bought a couple of houses from older people, and they understood it, and they were nice, and they got it, and they lived up to their end of the bargain, and I did too. So I don't. This whole thing about stealing houses from little old ladies, that's a fiction. It's a myth.
Yeah, I agree. Well, I'm just saying, Bill. Just these judges, you just don't know what they're going to. I mean, you're an attorney. You do this more than me. I mean, can you predict?
Right?
Yeah.
Same thing. A confused mind says no.
Mm-hmm.
A lot of judges don't understand this stuff.
So what makes it so hard, Bill? I'm going to get to some questions, and I'll let them get through the goodies in a minute. What makes it so challenging for people to find, or is it just that creative real estate is not that much volume? Is that why everybody's having trouble finding?
Yeah. That's, 99% of transactions, you list it with a broker, you sell it to a buyer who gets an FHA or conventional loan, puts a down payment down, gets a mortgage from a bank. That's your typical transaction.
Mm-hmm.
Dealing without an agent and doing something creative or subject to, not paying off the loan, not assuming it, that's probably less than 5% of the transactions out there that brokers, attorneys, and title companies are used to seeing. It's just ignorance.
It's rough. I'm thinking as many people as I have referred, I'm like, Bill, it's challenging finding these people. But
keep asking around. I mean, it's like in any city, because people say to me all the time, I can't find anyone to close one of these deals in my town. I'm like, it's the same in any town. You go to any town and ask 20 title companies, will you do a subject to closing and not tell the bank? I guarantee you 19 out of 20 will say no. But all you need is one, right?
good point. That's good.
One.
Okay, Roundup. When I was talking to Bill over the weekend, he did that video for us Friday about the wrap note stuff, and we gave you the riders, the documents that come with your deed of trust. So Bill's going to give us a Columbus Day special. We're getting a discount. Tell us about that, Bill.
Yeah, so I have a course called Creative Real Estate Financing. I have one on subject to and one on lease options. And you use the code that Kris is going to provide for you called HOPE, HOPE, and that gives you 50% off. Amazing.
Thanks, Bill.
So, just what's in my courses, they're online. They got course manuals, legal forms, checklists, contracts, audio, video, all inclusive, just like a trust deed.
Nice. Bill, thank you. So my thing is this, where are you going to get this stuff or even be able to see? I mean, it's so few people that are even practicing this type of stuff. So I'm pretty
You go to a local attorney and ask them to draft you up a set of documents. It'll cost you $1,500 for one type of transaction. I've got in my course 25 different ways to do it and 25 sets of forms.
Wow. All right. So I'm going to round up what, if you go to the video description, the link is there, or you just go to Kris Haskins. He's in my mentors. Use the coupon code HOPE for Bill stuff for Columbus Day. Get this wrap stuff and the subject too. You're going to understand how to do that. Walk through by an attorney.
Yep.
So what is the position when people say, Bill, what do you tell people when they call you? They say, well, I've tried 1 million people and the attorneys say this is illegal. What did you come back with that?
Say, what law is that? Illegal? Show me the law that says it's illegal.
Show me the law.
Show me the law. Show me the court case. Show me the statute. What law is that? And then they usually hem and haw and go, well, it's not illegal, but it's just not common. So you have to know the difference in your market between what's common practice and what is the law.
Common practice.
Because brokers will tell you that all the time. They'll tell you, no, that's illegal. And you'll ask them, what law is that? No, it's never done that way. Well, maybe you never heard of it. Doesn't mean it's not legal.
That's deep, Bill. I guess my heart just goes out to so many people that are unaware. That's all. I don't want to seem like I'm beating it in their heads, but I'm like, we do this every day.
Right.
Trying to just get people over that hump, man. That's it.
Yeah.
Okay, Roundup. That's been my time. I mean, I could keep going with Bill all day. I mean, I talk to him regularly already, but go ahead and use the coupon code. I like to get your questions answered from the attorney that does subject to and wraparound. So, Bill, what's the difference between a wraparound mortgage and wraparound deed of trust? Is there a difference?
Well, you use wraparound mortgages in states that use mortgages. You use wraparound deed of trust in states that use deed of trust. So it's about 60-40 in favor of deed of trust. California, Texas, Colorado, where I am, deed of trust states.
Gotcha.
New York, Florida. I think your state's mortgage, right?
Bill, I mean, well, we filed deeds of trust at the courthouse. I don't know if it's.
Oh, so then you primarily. I mean, they're legal and they're legal in both legal in most states. It's just there's a primarily one that they use.
Yeah, I've never seen a mortgage at the courthouse. I always see it, even when they index DOT. It's in the index machine is DOT. Okay.
Yeah, deed of trust, right?
Roundup, get your questions in today. Cheddar, how big of a discount do you need on a house when buying it to make money? Wow.
Get the lawyer answer there. It depends. It depends.
Well, Bill, go ahead, Bill.
If you're trying to buy, fix, and flip, you got to get it. You got to steal it. You got to get it really, really cheap. But if you're doing financing, there's like 6 factors you're looking at as subject to. Mm-hmm. Okay, so what's the value of the house? How much equity? What's the interest rate on the loan? Is it fixed? What kind of condition is it in? The age of the house, the desirability of the neighborhood. What would it rent for if you decide to keep it and rent it? So you got to kind of balance all those factors. How much money does the seller want? Is he behind in payments? So it's not simply a matter of, how much price. I bought houses worth 100 where they owed 110.
Mm-hmm.
I didn't care because they had a loan modification at 2%. So I could rent it, even though it had no equity. I could rent it for cash flow.
That's a big question, Cheddar. Here's the thing. I like to look at it. If you owe $1 million, but the payment's $1 a month, you can still do the deal.
Sure. Yeah, okay. I'd pay full price for a house and then some if they did it at no interest, or 2% interest.
Yep.
You ever seen one of those truth in lending statements? That's one of those oxymorons, truth in lending, like military intelligence or you see how much you pay and how much you pay in interest over 30 years. If you do it at no interest, fine. Saving
mad money.
Save a lot of money. I'll pay full price for a house and then say, you want full price? Fine, no interest.
Nice. You got some nuggets in there, Bill. You sound like you might have negotiated one or two of these things.
One or two.
Alabama. You want to hit this again, Steve? Steve wants to know how to find attorneys experienced is subject to at least options. I think
the best way to do this, go to your local RIA.
That's true.
And ask other people who's knowledgeable, which escrow, title company, or attorney closes these things, and you'll get a recommendation.
There you go. Frankie buys houses. Hey, Bill, can you write off interest on a first lien position private lender?
The interest you're paying, of course.
Yeah. Yep. Edgar, what happens to the wrap if the seller dies in the near future? I guess they have to sign off to release the satisfaction when you sell it. Good question.
So that's another reason why I'm not a big fan.
Explain it, Bill. Break this down so people.
If I took subject to the seller's out of the picture, if he dies, I really don't care. I really don't care. I mean, well, as a person, I may care.
You do care.
As an investor, I just don't care because it doesn't affect my ownership of the property that he already gave me. If I gave him a second on the property and now I want to resell it, how do I release that lien without his signature? So what I like to do is get a signed release and maybe have the title company hold it in escrow in case he disappears. It's more likely than not the seller will die, move, disappear, or lose it. Which is why I'm not a huge fan of putting the lien on the property.
So you're going to get the release when you deploy the wrap.
And have it held in escrow.
Sharp.
You know what they do in California, which is common? Because land contracts are a little weird because when you want to kick somebody out on one, not every state has a prescribed procedure. Like in Illinois, it says, okay, if someone defaults on a land contract, here's the process. You got to give them so many days notice and then go to court and go through a procedure. It's harder than an eviction, but it's easier than a foreclosure. Right? California, there is none. So if someone defaults, you could end up having to do a judicial foreclosure, which is longer than a trustee foreclosure. So what they do in California is some title companies will do is they'll do a land contract, and in escrow, they'll hold a deed and a deed of trust. So if the buyer defaults, the escrow company records the deed into the buyer's name and then a deed of trust back to the seller that the seller could foreclose through a trust deed foreclosure, which is 90 days.
Gotcha.
As opposed to a judicial foreclosure, which could take a year.
They got to get permission from the court, right?
Right.
Good luck.
That is a way of doing it. I think it's overkill. Because, like I said, I've done so many of these. I own an escrow company, so we specialize in closing wraps, land contracts in particular. And I lost count after like 1,200 of them. I've been doing it since like 1997. And I've yet to see a judge say, no, you have to do a judicial foreclosure. I've yet to see it. Because usually if your buyer defaults, they don't have money to hire an attorney to fight you. And you can give them a few bucks and get them to sign a release and then, be on your merry way. So it's so rare that you're going to end up, having to do that. So I think the practice, what I described of the escrow thing, and
good gracious,
is preparing for something that's going to happen 1 out of 200 times.
Overkill. Roundup, make sure you go head over to the link in the video description. Use the coupon code HOPE to get Bill's wrap course, creative financing, and you can use that code for any of his other trainings also for the subject too also. Good question, Edgar. Ultimate bargains. How about using a service company to receive the payments? You recommend that, Bill?
Yeah, if I'm making payments to the seller and hoping he makes it to his underlying lender, that's risky, especially if it's a mirror wrap. There's no profit for him there. You know what I mean? Every month. So I did it that way for years. I used a third party where you write a check to them and they pay it to the lender, and then if there's any spread, they write the difference to the seller. And send everybody statements every month. It's about anywhere from $20 to $35 a month, depending on who you use. Everybody's got an online account these days. Every bank has an online thing. So you go on the online thing and you log in. Or if they don't have one, you create one where it says automatic payments. You put the routing number and the account number of your account as the buyer, and then there's an email that gets sent to both the seller and you that confirms the payment. So much easier.
And it's over.
Yeah, so much easier.
Yeah, that's what we do. I just make it right online, Bill. I'm gonna mail it for, right?
Yeah.
Okay, get your questions in. Round up. Trevor, hey, Florida. Okay, so with all-inclusive wrap, do you include any liens outstanding, Bill?
With the all-inclusive, any liens outstanding, other than the first mortgage? Like, let's say there's a first and a second. Sure.
Wrap it all up.
Could be a third.
There is no, you can wrap as much in it as under there as you want, right?
Yeah, there could be a first, a second, an IRS lien, a judgment to the ex-wife. We can wrap it all.
Jonathan, hey, thank you to, you're welcome. You're welcome. We took our first subject to property back in February. God bless you. Good for you. Lease optioned it out. This was a deal analyzed. Wow. Good for you. Look at that, Bill.
That's awesome. I love hearing that. Makes my day.
Does Bill know anybody? Den. I love this. These come up all the time. Refer to us someone that could close, Bill, in St. Louis.
I know 6 in St. Louis. Which side of town are you on? I'm kidding.
Wow.
I get that question about 10 times a week. I'm sorry to tease you.
I get it all the time. I'm imagining how many.
There's a bunch of real estate investment associations in St. Louis.
Yeah.
Just go online, Google RIA, St. Louis, Missouri. Go to a meeting, ask around.
Gotcha. This might be a deep one. John Hollywood. Don't forget, Roundup. Head over to the link in the video description. Go ahead and get your creative financing course now. Get your wraparounds done. Bill, can you provide the names of every document? That might be a little rough for this short thing here.
Off the top of my head here, but I do have in my course a checklist.
There you go.
This form, this form, this form, this form. You know what I also have in there? An attorney's guide to closing wraparound transactions. It's like a 4-page description that you can hand to your attorney and explains to him what I do.
Nice. Nice. Jonathan said you've been an invaluable source of information. He wants to give you a hug.
Thank you, John.
Joseph, when you buy sub 2 and sell on a contract for deed, is it still considered a wrap?
Yes.
So do you need RMLO if you're doing CFD? Uh-oh. I know what that is.
Yes.
What's that, Bill? Break that down.
It's a registered mortgage loan originator. So when you sell on a contract for deed or an owner carry of any kind, except the lease option, that usually doesn't apply, to an owner occupant who's going to live in the property, you got to comply with Dodd-Frank. I go over that in my creative financing course. I go over the rules, like how to do it, how to comply. I wouldn't say it's easy to comply, but it's not that big of a deal.
Yeah, we do.
It's not a deal killer. People say that every time a big new law comes out, everyone says, that's the end. It's all over. Sky's falling. I remember when they said they were going to give people a 3-day right of rescission on refinances. Every mortgage broker in America said, that's it. Our business is dead. Everyone's going to shop it in the 3 days. Nobody does that.
Mm-hmm.
Have you ever heard of someone doing that? Like during the 3-day rescission on a refi, like shopping it around and then canceling?
No, they're waiting to get that money.
500 times. Same thing with, when they said about requiring, Dodd-Frank requiring all these regulations that have to do with owner financing. I wouldn't say it's business as usual. We're doing different things. We're doing different disclosures, but for the most part, it's doable.
Good. All right, Bill, we got 95 people on here to hear what thus saith Bill Brunchick. Tony, Bill, are you licensed to close transactions in any state?
No, New York and Colorado. That's where I'm licensed to practice law.
Justin, can I get them to sign an agreement in advance to the deed the property should they decide to file bankruptcy in the future?
Of course you can. What if they don't do it?
Yeah.
What if they don't do it? You know, it's fine to put it in writing, but it's more of a relationship thing. Just keep in touch with me.
Be smooth with them. Yeah.
If you decide to file bankruptcy, or you're going to move, or something with the house, or you're going to do something, please contact me first.
Now, is the deal dead if they file bankruptcy on a sub-2 deal or what?
No. On a subject to, it's not, because you already have the asset. It's when you have a lease option, land contract, where you have an unfinished business there. They still have the deed.
Gotcha.
And you don't. So what you have to do is you have to go to the trustee in bankruptcy and say, listen, there's no equity in the property. We have this deal. Can he deed me over the property? And most of the time, the trustee in bankruptcy will say, fine.
Yeah, those dudes are sharp.
Yeah, and they don't get paid much either, so they really don't want to argue about it.
Oh, I didn't know that.
No, they get paid bupkis.
So the attorneys are the ones sucking out all the money in these bankruptcies.
Yeah, pretty much.
Ashanti, why is it so hard to I don't want to beat that one up again. Ashanti, I'm not trying to. We've obviously covered that a couple times. I still love you though. Bill, does your creative financing course also cover subject to? Good question.
It does. It does. The subject to course covers it in a little more detail. That's why it's cheaper. But the creative financing covers wraps, subject tos, lease options, and a bunch of other stuff. I have a specific one on lease options and a specific one on subject to that are, just focused on those two topics. The courses are a little cheaper and they go into a little more detail. So if you want to really, get an education, you get all three, or two of them. And I'm actually coming out with, in about a month or so, I'm going to re-release a course I did 20 years ago. One of my first courses on the topic called How to Create a Real Estate Cash Cow, just on wraps.
Nice.
Just on wraps.
Nice. Tell them, Bill, they don't have any idea how challenging putting these courses together are.
It's a lot of work. A lot of work. A lot of research, too, because I want to make sure this works, in every state. So I do a lot of legal research for all of them. Most of these, gurus out there, they're like, well, I'm from Florida, so check with your local attorney.
Yeah.
Make sure it works there. And I usually get a bunch of Florida forms that don't work. Or Utah. Seems like every one of the crooks is from Florida or Utah, isn't it?
Round up, make sure you head on over to Bill's site. It's in the video description. Use the coupon code to get 50% off of his creative financing and the subject to and the land trust stuff, which is what we have too.
Someone says, what up, guys? Great info. The link isn't in the description.
Oh, it isn't? Uh-oh.
I'm just reading a comment there.
I see it here. It's working for me. If somebody let me know, please check on it again. It's working. I see it here on the site. That might have been you know what? I didn't put it until later in the thing. These are early questions here.
Oh, okay.
Sorry about that, y'all. Okay. Edgar, how should we properly do the insurance change when we're doing a subject to, Bill? Good one.
Excellent question. So the seller usually has an all-inclusive payment of principal, interest, taxes, and insurance, right? And its mortgage. Ideally, I want to keep that insurance in place, that policy. But the problem is, if it's an owner-occupied policy and now you're a landlord, how are you going to change that policy without changing the nature of it? And the insurance company may not underwrite landlord policies. So you'd have to cancel it and get a new one. The lender gets a copy, potentially triggering the due on sale if they really care, which they probably don't. But that's the way to do it. Now, when you get a new policy, make sure that the seller is an additional insured, because their computer will spit out a letter saying it doesn't match the borrower. Mm-hmm. You'll keep getting that letter and they'll keep getting annoyed. The foolproof way to do it is to just leave the payment alone. PIT, I keep paying it, and get a second insurance policy that just names you.
Me.
The problem with that, though, is the price. If you're in an area where it's an extra $600 a year for that type of house, Yeah, go ahead. $600 a year. Yeah, why not? But if it's if you're in Florida where it could be like $2,500, not good.
Yeah, Ron LeGrand called me a wimp for doing that, Bill.
A wimp?
He said, "You're a wimp."
Well,
my thing is, I want to sleep at night, Bill. I don't care how much.
It's cheaper in where you are than where he is.
Yeah, he's in Florida.
He's in Florida. Insurance. Well, half the insurance companies don't even insure properties that are in hurricane zone. You have to go to the state fund, which is expensive and restrictive. So,
well, the second policy,
we used to do it that way in Colorado because insurance used to be, like I said, it used to be like $500 or $600 a year, and now it's more like $1,300, $1,400, $1,500 because of all the windstorm damage. We get to roofs.
So the second policy, house burns down, you don't even touch the policy that's in place with the seller. You just deal with the one that you have, correct?
Right, because that pays you, and if there's any, and the other one pays the lender.
Gotcha. Ashanti, can you say again, how do you explain to seller? Explain what? I don't know, Bill.
How to get him to deed you over the property?
I don't know.
Hey, Chris, what do you owe?
I owe $48,000.
And what's it worth?
I think it's worth $60,000.
Okay, so if you sold it with a realtor, how much after you paid off your mortgage would you probably walk away with?
I already talked to Sally. She told me I'd walk away with about $3,500, $4,000.
Okay. So how about if I give you $3,500 and you just transfer ownership to me and I'll make your payments? We can close next week.
I think, wow.
I mean, that's as simple as it is. I mean, just keep it simple. If you start going, well, we're going to do a wraparound all-inclusive mortgage, and then do afterwards, because that's probably not going to be a problem. We're going to change the insurance, and and this is what the lender's going to say. Blah 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 blah. And people just, the guy's head's just going to explode. Don't over-explain it in the beginning. You'll get to that eventually, but don't over-explain it.
Keep it simple.
Keep it simple, stupid.
Trevor, is the wrap trending to be the transaction to be carried out? Is the wrap trending to be the transaction to be carried out?
Is this the new thing? Well, we've been doing it a while, but I've been doing it for 25 years.
Tony, what loans can't
be wrapped? Good question.
Is there a loan that can't?
FHA is not a problem. If people think that FHA loans can't be wrapped or subject to, that's not true. If there is a co-sponsored state low-income program, with that, they will call it. So the 3.5% down, the local housing authority provides that 3.5%. And if you take subject to, boom, they will call that. We have an organization in Colorado called CHAFA, Colorado Housing and Finance Authority. If they put up the 3%, so that it's co-sponsored with FHA, and even if the seller moves out of the property and rents it, they'll call it too. So it's solely designed for the low income, local housing provider government program. Or the other ones that you can guarantee they'll call is a reverse mortgage.
Oh yeah, we can't.
Reverse mortgage, you can't do a wrap on.
Y'all, please don't be trying to do deals on these reverse mortgages. I've seen so many people. I'm sure you have to. Yeah. Try to make a deal.
What you can do is maybe a short sale,
maybe
insured, which is not got a big discount. There's not much you can do with a reverse mortgage unless there's equity.
Roundup. Don't forget, use the coupon code HOPE. The link is in the video description for Bill's creative financing and all of his other courses. Go ahead and invest in your future with that for this Columbus Day discount Bill's giving us. Thank you. We got 105 people on here, Bill. Thank you, guys. John, I was told in Pennsylvania to do an irrevocable trust rather than a land trust. Make the beneficiary first. Once the deed was registered at the county, to change it to the LLC.
Pennsylvania does not exempt transfers into land trusts from transfer tax, which is about 3%. So at a $100,000 house, that's $3,000. That's a chunk. But look, you're buying the house.
Pay.
No matter how you slice it.
Mm-hmm.
So just pay the 3%. I mean, it is a sale.
I think we're 1.8 here. Yeah, it's going to cost, even if they give you the property, John, you got to pay. Just price of doing business, bro.
Yeah, there's no exemption. They exempt what are called living trusts in Pennsylvania. So I have a form in my land trust course, which looks like a living trust for use in Pennsylvania. And then after we file with the county and they exempt it from transfer tax, then we go amend the trust and put it back into a land trust.
Land trust, guys. Land trust. Don't try to fight it. Ryan, on a lease option, do you retain the title to the house, or do you sign that over to the buyer whilst the buyer is actively paying the monthly payments until completion?
The former. You retain title.
Try
On a land contract, lease option, contract for deed, seller retains title.
Hands-on real estate. Are you still knocking on doors? Not in this COVID time.
Only if I want to get invited in for coffee.
Yeah, not now.
Or it's my in-laws.
Life beyond fear. Bill, have a property that I'm doing a sandwich lease, but the owner filed a Chapter 13, and I took it anyway. Is that okay?
Technically, in Chapter 13, the debtor's in possession of his assets. So he could do that. He just can't take on any new debt without the permission of the bankruptcy trustee. So I would say you're probably fine, but next time I would talk to the bankruptcy trustee.
Boy, Chapter 13, do you have prop? Nice. Do you have to give the seller some interest to make the contract legal?
No. Now, can the IRS impute interest? Like if you're selling me your primary residence for an inflated price, but still within the exemption, the 250 exemption, right? And we said no interest, and we just inflated the price. The IRS can impute some of that as interest and tax it.
What do you
mean? Interest rates are so low.
Yeah.
When interest rates were 11, if you sold something with no interest, the IRS would impute some of that as interest and charge you a different rate. Because remember, capital gains rates on principal is lower than ordinary rates on interest.
Gotcha. 7-day services. I'm in DC currently looking for a subject too. Oh, okay. Best way to buy. My favorite way to. Let me ask you. That's my favorite way to buy, Bill. What's your favorite way to buy?
Favorite way to buy? Give me the deed.
Kevin, hey, is it okay to purchase new home insurance and leave the existing insurance? I think you just covered that.
You talk about that. That's
what we do. Yep. Den seems like no. Bill, if you want to speak to the lender to negotiate the payments, is it best to explain that I am buying subject to?
No, do not do that. If you have a power of attorney, just say, I have a power of attorney and I'm negotiating with you for so-and-so.
Just call. You don't even have
a lot of chutzpah, to go to a lender with a house 11 payments behind and say, let's do a forbearance and a loan mod and then take subject to. It's not illegal, but it's chutzpah.
That's some guts.
It takes guts to do that.
Hey, Tony D's, if we buy in a land trust, are we exempt from Dodd-Frank?
When you're buying, you're exempt from Dodd-Frank, period. If you're not buying to live in, if you're buying as an investor, Dodd-Frank doesn't apply. It's only when you're selling to a buyer who's going to live in it that Dodd-Frank applies.
Roundup, thank you for coming on. This is Bill Brunchy. We got 105 people on here. Make sure you go to the video description below to get Bill's creative financing course that covers all this stuff and all of his other courses too. Jonathan, do I ever consider fix and flip from a sub two? Absolutely. Done it all the time. Mm-hmm. I don't care as long as the numbers work.
Sure. It's cheaper than hard money.
That's right. I remember we bought one Bill. The guy's payment was $75.
Oh, jeez.
75. I'm like looking at the payment thing. I'm like, couldn't afford this.
Yeah, that's not even dinner.
When you can't afford it, Bill, you can't afford it. Jamal wants to know, Bill, what are your thoughts on Zillow? Oh, what are your thoughts on Zillow becoming a brokerage?
It's smart of them. They're getting a commission on all the properties sold in there.
Mm-hmm. Bill, John, what is the cost of your course? You mentioned 50% off if you purchase it within an hour after the stream ends. Would you give us 75%? Oh, come on, guys.
Come on, guys. It's already cheap to begin with.
Yes.
We're starting off, it's even cheaper. It's not, as Zig Ziglar used to say, is it price or is it cost?
Guys, I've negotiated this stuff before you even get on here. Boris, I'm looking for a substitute deal in Dallas. Do you think it's harder to find such deals in a super hot market where sellers have a lot of equity?
Dallas might be a hot market, but it's not as hot as my market. I'm in one of the hottest markets in the country, Denver.
Oh, that weed people moving in Denver.
Yeah, so we still find them here. There's always people with problems.
Always
people with individuals with problems, regardless of what the market in general is doing. There's always people with problems. Especially now, we're going to have COVID divorces.
COVID divorce? What's that?
Yeah, from being locked up with your spouse for 6 months. COVID divorces. And COVID babies.
I had a COVID baby.
Yeah, there you go.
All right, Joseph, how do you explain to the lease option buyer that you bought the house subject to? Just in case the due on sale clause.
You don't have to explain that you bought it subject to. You could disclose to them that there's an underlying loan that might be called because you took it subject to. I guess you could put a clause in there, but it really shouldn't affect them because your lease option buyer is going to be buying that property within 2 or 3 years, max. So the odds of that loan being called within that short time period are pretty slim. Should you do it? It can't hurt. It can't hurt.
Mm-hmm. Desi, the link is not. Y'all, can somebody check to make sure that link is in the video description? I thought it was in there. I'm seeing it here, but that doesn't mean it's there. Britt, I'd be interested in that course. Cool. Yep, it's right on there. Just go to the video link in the video description. Hey, Britt. Ryan, Bill, if a home is currently in pre-foreclosure and the owner is residing in an assisted living facility, very common, how can you find the party that can negotiate their property? Family member.
Someone with the power of attorney. Someone's got a durable power of attorney, probably one of the kids.
That's what I did. That's what we did. Yep. Trevor, in Florida, how do you deal with the taxes if the property is not in your name? Let's just say income taxes, Bill.
Income taxes. Okay, good question. So Chris has a house he bought with his mortgage in his name. He transfers to me subject to. His lender is still sending a Form 1098 to Chris every year saying, here's your interest for the year. Okay. Chris can't take that deduction. He doesn't own the house anymore. And he's not making the payments either. Who's making the payments? I am. Who owns the house? I do. Who can take the deduction? Me. Now, if I took it as my primary residence and I lived in it, I could take it on my Schedule A as a mortgage deduction up to $10,000 a year, right? If I took it as a rental property, then it's just a line item on my schedule of my LLC tax return. It says for each property, there's a line item on the schedules. It says rent, vacancy, mortgage payment. Even though the mortgage is not in my name, it's in his name. It's okay to take it. The rule is if you have to own the property and you have to make the payment. If you meet those two criteria, you can deduct it.
I'm telling you, Bill, during my audit, I had to bring my trust in because they were like, what is this 123 Main Street Trust? And, and the loan was in the seller's name. They're like, how are you claiming the interest when the loan's not in your name? I had to prove that I was the owner, Bill.
Yeah. If you own the property, you have an ownership interest and you make the payments, you can take the tax deduction.
Yeah, they didn't have any problem. She just said, I just want to make sure you own it.
Okay.
Phoenix, what happens if the market shifts and the home won't appraise?
In what scenario?
Yeah, lease option.
Rent until it comes back. Remember 2009? Buy more.
Yeah, lease option. Yeah, that's a good question. Sven, I
like this one. I wonder if mistakes Bill have done earlier, so I don't make the same mistakes as a new instructor. Oh my God, you got about an hour? Yeah. Experience. I'll tell you one. I took a deed subject to without even doing a title search. It was a foreclosure. It was like a day and a half to the foreclosure, right? So I just ran over to the lady's house. I gave her $2,000. She deeded me the house. I took a risk. What I didn't know, and I called the lender too to verify. What I didn't know, it was in an FHA HUD assignment program.
What's that?
Where basically HUD takes it back from the lender and works out a negative amortization payment where the balance is getting bigger and bigger and bigger. So I thought, it was only like 80 owed, and it turned out it was like 110 owed. And she duped me, and she wouldn't give me money back.
You won't do that again. Tabletop closing.
I'm not saying I wouldn't do a tabletop closing, but that I didn't know about this HUD assignment program. I never heard of that before that. So if it's an FHA loan, be careful of that.
No, Phil. I live in Baton Rouge, and we're a mortgage state. Okay, I was told that we only have living trusts and not land trusts.
Yeah, land trusts are technically not valid in Louisiana, but I use them anyway.
Revocable grantor. Can you use it?
Just use a modified version of a land trust. That's all.
Same thing. No.
If you're in court arguing over the validity of the trust, the point of the trust was just blown. Anonymity.
Oh, you're there.
Right.
You're there. Tony Deeds, on a wrap, what happens when the term ends and the property is still not paid off?
It can't be. I mean, if you structure as a mirror of the underlying loan, when the underlying loan's paid off, your debt to the seller is done. Mm-hmm. If you sold it like on a wrap, what the buyer owes you is always going to be more than what's on the underlying loan, unless you reverse wrapped it and took it as 6% loan and wrapped it at 4%.
Mm-hmm. It will be paid off.
It could get negative in theory. It could. I mean, I've seen it done. Not very smart, but I've seen it done.
Hands on, how do you find your subject to deals, Bill? You got a course?
I go to Chris's house when he's sleeping, and I go into his file cabinet, steal all his leads. He's got a yellow thing right there on his desk. Is that a yellow pad, or is that a flyer?
Which one? Right?
Your right hand.
Well, this is my home investors. I used to be a franchisee.
Oh, okay. Is that a marketing piece?
It was when I had a franchise. Yeah, I got a whole bunch of letters over.
I was gonna buy a franchise from them, and then they said in the franchise you can't do subject to deals on the side, and I said no way.
I should have listened. I would have saved $30,000. They didn't tell me I couldn't do subject to until after they took my money.
Oh boy.
Let's go ahead, Bill. I know your time is crunched. Let me see here. Ryan, if you're doing lease options, then you're seller financing, hence no lender. Oh, that's a statement. Oh man, so much. The link there is functioning. Already priced the program on. Okay, nice. Okay, link is. Man, they checking around, aren't they? Ryan, thank you. No link in video description, Chris. What? Somebody just said it. Bill, what do you think? I don't know. Oh, it is there. Okay. I got 2 people says it is. I'll go with 2 to 3. How about that?
Oh, yeah. 2 out of 3 is good enough.
Bill, somebody wants to know, Javier, can we go over once again, what's the best course to start with? I'm new to subject to and creative financing. I'm only wholesaling. You got a hammer. You're only wholesaling means everything you look at looks like a
name. Yeah, I would. The creative financing gets the best bang for your buck because it covers all the topics, even though it's more expensive than the subject to course. If you just want to do subject to, then get the subject to course. If you want to learn a lot of ways to creative finance, get the creative financing course.
Well, subject to is going to be the most powerful way, I think.
Right. If that's, if you have a hammer, that's your wholesaling, and you wanted a screwdriver, get the subject to course.
Good point. Round up. Go ahead, head over to that link in the video description. Get your discount here. Prop Nice. Do you ever stay in the middle of a lease option for sandwich lease, Bill?
Mm-hmm. I usually always do. I don't like assigning it off and then hoping it all goes well. I don't really like doing that.
Hope. Only reason I use hope is in this discount. I do not like using hope in my business.
Hope is a good political strategy.
Christ. Bill, what's the name of the course that covers all the stuff we were talking about today?
Creative real estate financing.
Creative real estate financing, overcoming in Christ. We've got 103 people on here. Bill, do you get an EIN number to claim the interest? No,
you don't need to do that.
Smooth Lou, I'm working on a property in Memphis. Current tenant has destroyed the property and the owners can't afford to fix it up. but want to sell it for top dollar, what would you recommend?
Just the way it is, and sell it on a wraparound to a contractor who will do the work in exchange for the down payment.
Ugly one, ugly lease option.
Yeah, ugly lease option or ugly subject to.
Subject to, yeah.
Yeah, I used to have a sign that said rent to own, the number 2, rent to own, 0 down, the letter U hyphen fix.
Nice.
So rent to own, 0 down, you fix. Oh my God, I got so many calls on that. If you can't sell a house the normal way, throw a brick through the window and call it a handyman. Everybody wants to be a handyman.
They love it.
Everyone wants to be a fixer-up. It's like a state sale. It's a buzzword.
They love it, don't they?
Yeah.
I don't have any problems, Bill, selling ugly houses.
Ugly houses are much easier to sell than pretty houses, I think.
Roundup, if you head over to the link, matter of fact, let me do this. People are still saying it's not there. Just go to my website. Go to krishaskins.com. What am I doing? Oh, just go to krishaskins.com and go to my mentors. It's right there. Bill's stuff is right there.
Yeah, there you go.
But you got to use the links on my site to get the discount, y'all. So, yeah. Last question here, and we'll let you get out of here. It's 2 here, Bill. Kevin, does the power of attorney immediately expire after the death of the buyer? I think you mean seller.
Yes. Now you want it to be durable, which means if he is in a coma, it still works.
Not durable.
But the death of the principal expires the power of attorney. Yes.
Andy, what about taking a sub-2 with a second mortgage that's still in a good? Is that a good deal or not?
Sure.
Yep. Anytime you can buy a house, and let me ask Bill. My thing is that anytime you can buy a house without qualifying for a loan is a good day, right?
I've taken properties with first and seconds and negotiated off the second and took subject to the first. That's another one in the creative financing course.
Nice. Bill, thank you so much for your time, man. We got 100 people on here.
Love you. Thanks everyone for joining. Happy Indigenous Columbus Day, whatever they call it. Don't tear down any statues. Just go out and make money, okay?
Go make money. Then you can move where you want. The link is in. Just go to Kris Haskins, my mentor. You can use the coupon code HOPE for Columbus Day special. Bill, final thoughts on this creative financing craziness that when I talk to a real...
There's going to be so much opportunity with all these COVID non-pays and deferment programs.
Oh, boy.
We're going to see so much opportunity over the next year. So, gear up. Gear up. Get the tools you need to do these types of transactions because most people don't know how to do it.
Mm-hmm. All right, Roundup. That's all I got. Please head over. Once again, I put the link in the video description.
A round of applause for Kris Haskins for putting this. What a guy. What a guy. Look at that. No wonder he got platinum records on his wall.
I'm thankful. Baby.
The maestro. The maestro.
Yeah, maybe I should do that. Let me change my name. All right, let me change this out. So if you go to the video description, the link is in the video description. I put it in there personally. Use the coupon code HOPE. That is my special link, so you can't get it anywhere else. You got to use it. And if you can't find it, just go to my site and go to my mentors, and you'll see Bill's stuff on here. All right, Bill, that's all I got for you.
All right.
Roundup, make sure you subscribe, hit the like button, and share this information with other people that are interested in creative financing. I'll talk to you soon, Roundup. Oh yeah, I got a sponsor now. What is that? Look at that. Kris Property Data, PropStream. They're sponsoring the show now. Finally, after 5 million views, we get a sponsor. Isn't that something? All right, I love y'all. Here's the link. I hope the link is in the video description. I put it in there. I don't know.